Picture this. The T mark on your cheek wasn't a punishment. It was a receipt. Proof the court had already spent its mercy on you once. You're in a market square, a Tuesday in 1653, and you are doing something stupid. The stall in front of you has bolts of dyed cloth stacked in loose towers. Pale blue, rough broadcloth. A single bolt runs 24 to 30 yards and weighs somewhere between 20 and 30 pounds. That is roughly the weight of a medium-sized dog. You tuck it under your arm anyway and start to turn. The vendor screams. Under hue and cry doctrine, every bystander who hears that scream is legally required to give chase or face a fine themselves. Within seconds, half the market square is running at you. You are holding 30 pounds of cloth. You are not fast. The constable catches your arm before you make the alley, and the bolt hits the cobblestones. And that is the last free decision you make for a very long time. Oh, hey there. I'm your dead host, and today we are walking through one of the most bureaucratically precise forms of state-sponsored cruelty ever put on the English statute books. Thermal contact necrosis, if you want to get technical. Judicial branding, if you want to sound like a history book. A hot tea pressed into your face, if you want to be honest about it. The court had two options for you. They could hang you at Tyburn, where on a busy day the crowd ran to 100,000 people, or they could brand you, stamp the ledger, and send you back into the world as a walking warning. You were not important enough for Tyburn. That was, technically, the mercy. Here is what the law actually said. The Statute of 1547, revised and extended by 1563, codified benefit of clergy and its limits. Benefit of clergy was a medieval loophole. If you could read, you were technically clergy, and clergy had different courts. By the 1600s, the test had collapsed into a single verse, Psalm 51, verse 1. Have mercy upon me, O God. You had to recite it from memory in front of the magistrate. They called it the neck verse, because if you could say it, you kept your neck. If you could say it convincingly, the felony downgraded from capital to clergyable, and instead of a rope, you got a brand. Your life, down to one Bible verse. The brand was the T. T for thief. First offense, non-capital, clergyable. It went on your left thumb by default. A second conviction moved it to your cheek or forehead. The T was pressed by a branding iron heated in a charcoal brazier to roughly 700 to 900 degrees Fahrenheit, dull orange, held in contact for 2 to 3 seconds. The mark was approximately 25 millimeters across, about the size of a silver sixpence, legible to any magistrate or employer for the rest of your life. Now, about the cloth you stole. One bolt of broadcloth in the 1650s was worth 10 to 20 shillings. 1 shilling represented 1 to 2 days of wages for a day laborer earning 6 to 8 pence per day. You stole somewhere between 2 weeks and a month of honest wages. Under English common law, any stolen goods valued above 12 pence, 1 shilling, qualified as grand larceny, capital felony. Theoretically, you hang. Mega Millions jackpot of bad luck. A Tyburn hanging cost the state a rope, a cart, a hangman's fee, roughly 1 shilling all in. But it also cost a laborer, a body, a warm pair of hands the market town would have to replace. Branding cost approximately 2 pence in charcoal and ironware. Parliament ran the arithmetic. The arithmetic was not sentimental. One historical footnote. In 1699, Parliament briefly tried cold branding, silver nitrate staining instead of fire. The idea was to reduce the mortality rate from wound infection. It lasted a few years. They reversed it. The cold brand faded. Constables complained that a thief could scrub the mark off within months. So they brought the fire back. Here is the timeline. Interval 1. Arrest to jail, same day. The constable delivers you to the county jail. In 1653, if that jail is Newgate, you are placed in a cell averaging 8 to 12 people in roughly 10 by 12 feet with no ventilation. The disease inside Newgate has a name: jail fever, typhus. It killed approximately 25% of prisoners awaiting trial in 17th century English jails. Your heart rate is normal, maybe 80 to 90 beats per minute. You are alive. You are not guaranteed to stay that way before the trial even happens. This next part gets weird. Interval 2. Sessions Day, morning. Arraignment. You kneel on stone in front of the magistrate's bench, shackles on your wrists. The statute book is open, dog-eared to the relevant page. The magistrate asks if you claim benefit of clergy. You do. He tells you to recite Psalm 51, verse 1. Have mercy upon me, O God. You say it. Your voice does not shake, or it does, and it does not matter because the words are correct. The magistrate notes it in the record. He downgraded your charge. You are no longer a capital felon. You are a branded one. Your heart rate is somewhere around 110 beats per minute. Your hands are cold. Interval 3. Sentencing, same morning. The sentence takes under 5 minutes to deliver. Branding in open court, possibly the pillory. The magistrate could stack those too. 1 to 2 hours in the Market Square pillory, crowds throwing rotting produce, offal, dead cats, stones. Documented cases from the period record fractured skulls and fatal eye injuries from pillory sessions. He does not stack them today, just the brand. He says the words. The jailer moves. Interval 4. The branding, same afternoon. A small antechamber off the court, a low wooden post, a leather strap nailed to it. The brazier is already glowing, orange-red in the corner. The branding iron handle protrudes from the coals, the flat, T-shaped tip cherry-red and visible. The brander is a thin, older man in a leather apron, sleeves rolled to the elbow. He does this every sessions day. You sit on a low stool, left cheek turned outward. The leather strap goes across your forehead and is pulled taut. Your head does not move. The entire formal procedure, from the moment the jailer heated the iron to the moment the iron lifts off your skin, takes under 5 minutes. The magistrate's spoken order is the legal trigger. The brander extends the rod. Contact time, 2 to 3 seconds. At 700 to 900 degrees Fahrenheit, the iron does not just burn the epidermis. It chars through the dermis and into the subcutaneous tissue. That is a full-thickness burn. The nerve endings in the dermis fire once, massively, and then the tissue is dead and they do not fire again. Yeah. I can do it. Your heart rate spikes. Your blood pressure spikes. Your body dumps adrenaline. None of that changes anything. The iron lifts. The brander dips a rag in the bucket of cold water and presses it to your cheek. The cold water is not medical treatment. It is just what they did. Interval 5. Days 3 through 5. Post-branding. You have been released or remanded to a house of correction for hard labor, beating hemp, grinding grain, 12-hour shifts on bread, water, and occasional broth. On day 3 to 5, the burn site develops edema. It swells. If it suppurates, pus forming in the crater, that is the beginning of possible cellulitis. Without antiseptic treatment, unavailable in 1653, wound infection could progress to sepsis within 1 to 2 weeks. A significant minority of branded convicts died of the wound rather than the sentence. The state had accounted for this. The arithmetic still worked out. All right, but what does this actually feel like? Survivors and petitioners from 17th century records describe the initial contact as a sound before a sensation, a hiss. Some describe it as an absence of pain in the first moment, followed by a pain that arrived all at once, like the body catching up to what just happened. That matches the physiology. Full-thickness burns destroy the nerve fibers at the contact site. The worst pain is at the edges, where the dermis is damaged but not destroyed, where the nerves are still alive and firing. Hey, that's not the mercy part. Your vision narrows, hearing goes muffled, your sense of time compresses. Some survivors describe the room going distant, like everything is happening behind glass. As healing progresses, collagen contracts and pulls surrounding skin inward. The resulting hypertrophic scar is permanently raised, pale or dark depending on complexion. It cannot be shaved, tanned, or powdered away. Every magistrate, every employer, every innkeeper you ever stand in front of for the rest of your life sees it immediately. You, the person who grabbed that bolt of cloth on a Tuesday, the person who knew Psalm 51, who got the words right and kept your neck, you are already carrying the permanent record. Judicial branding remained on the English statute books until 1779. That is over 200 years of state-run facial scarring as a sentencing option. A second theft conviction after a thumb brand resulted in a cheek brand, an F for felon on the forehead, a deliberate social death. No employer, no innkeeper, no parish would touch you. Post-1660, judges increasingly combined branding with transportation to Virginia or the Caribbean as an indentured servant for 7 to 14 years. Indenture mortality in the first 2 years in the Chesapeake ran at approximately 25 to 40%. Transportation was a probabilistic death sentence wearing the paperwork of mercy. The state was very good at this. It had a lot of practice. Stay safe out there. Avoid market stalls. Keep your arms at your sides. You know, common sense stuff. Hit subscribe if you want to keep exploring the worst ways to go. I'll be here. I'm dead.